the constitutional framework for environmental protection in Hungary, we should note that this is not without antecedent, and it dates back to the change of the regime with the constitutional amendment of 1989, when the right to a healthy environment was included into the constitution. Now the currently in force Constitution of Hungary was adopted in 2011, and it is in force since 2012. That is called the fundamental law, alaptörvény in Hungarian. When talking about the actors who are responsible for shaping the constitutional approach to environmental protection, first we should mention the Parliament, who has a major role in the adoption of the fundamental law, as well as the adoption for cardinal laws and several other acts. But another actor which is very important is the Constitutional Court, who has a key role in the interpretation of the environmental principles and the environmental provisions of the constitutional fundamental law. I would like to mention a few key decisions. The first one is from 1994, which is called the Fundamental Environmental Constitutional Court decision, because it interpreted the nature of the right to a healthy environment, however, in the light of the previous, the former constitution. It is also cited for its importance for declaring the principle of non-derogation, which basically means a prohibition from a deterioration of a previously achieved level of protection. And at this time, it was established for the procedural and the substantial framework. The second one, which I would like to mention, the second Constitutional Court decision, is from 2015. It is worth noticing that this was issued after the adoption of the fundamental law. And it basically reaffirmed the findings of the previous Constitutional Court practice, namely this one from '94, interpreting the nature of the right to a healthy environment, but in the context of the new fundamental law, and thereby adding several other aspects of it which are declared by the new fundamental law. The third very important Constitutional Court decision, which I would like to mention, is from 2018, and it pronounced a complex interpretation of the precautionary principle, which in this sense might be used jointly with the non-derogation principle, or in case if it is not applicable, in case if it is not applicable, it might be applied independently, meaning that the legislator is obliged to consider the risks that might occur according to the scientific viewpoint at the time of the decision making. Another very important actor who has a role in shaping the environmental protection in Hungary is the Deputy Commissioner for Future Generations. His activity is worldwide recognized at the international level by the UN Special Rapporteur for Human Rights and the Environment, for example, and his practice is quoted several times as a good practice. In the framework of his domestic activity, we should mention that he is entitled to issue opinions, recommendations, and the interpretation of the law. And he has sent amicus curiae to numerous key constitutional court cases, including the one that I have mentioned previously, the one from 2018. The Fundamental Rights Ombudsman is also entitled to be the petitioner at the Constitutional Court, and this was the case in the decision from 2020, which pronounced that the obligation to preserve natural values for future generations is a part of universal customary law. Talking about the fundamental rights protection, as I have mentioned previously, the fundamental law pronounces the right to a healthy environment. However, this is not the first time that it appears at the Hungarian constitutional level, but with this wording. And it was mainly interpreted by the Constitutional Court decision from 1994, and it was reaffirmed by the later Constitutional Court practice. So, according to the Constitutional Court, the right to a healthy environment is a third-generation fundamental right, which is not a subjective one, but its objective side is very important and is predominant, meaning that it requires an active behavior from the side of the state. The Constitutional Court also pronounced that the right to a healthy environment is in strong relation with the right to life, meaning that it stems from the right to life, it originates from the right to life. And however, talking about the institutional protection, we should mention that this is not arbitrary. So in the context of the principle of non-derogation, there is this limit, and it was broadened by the decision from 2015 with the organizational or administrative aspect. The right to a healthy environment is related not only to the right to life, but also to the right to health, to physical and mental health, as it is formulated in the fundamental law. Namely, that we can see it in the last row, that ensuring the protection of the environment serves as a tool for the effective application of the right to health. There are other interesting provisions in this article related to the right to health, pronouncing the agriculture-free of genetically modified organisms, the GMO-free agriculture in Hungary, as well as the access to healthy food and drinking water, which is considered to be a state task. Another important aspect which emerges in relation with the constitutional regulation of environmental protection is related to the liability issues. In the same article, which guarantees the right to a healthy environment, there is a statement that anyone who causes damage to the environment shall be obliged to restore it. And in the Hungarian scientific literature, there is a debate about whether it could be considered as a polluter pays principle or not. I have read one dissenting opinion of the Constitutional Court in which the judge stated that due to this article, the polluter pays principle appears at the Hungarian constitutional level, but if we read very important works of the scientific literature, we can see that it's rather a narrower understanding of the polluter pays principle, because the precautionary principle and the principle of prevention is missing from this article. In the same article, there is the prohibition of the transport of pollutant waste into the territory of Hungary, which was incorporated into the fundamental law due to a real case which happened, the so-called German garbage case. And thirdly, we shall mention Article P, which declares the obligation of the state and of everyone and to protect and maintain the natural resources. It is important to note that the fundamental law broadened the scope of the bodies of the subjects who are obliged to preserve, to maintain, and to protect the natural resources. It is not only the state task, but also the task of everyone. As for the protection of natural resources, we can find it in the national avowal, which could be considered as a preamble of the fundamental law, which provides the framework for the protection of natural resources, which is mainly described or pronounced in Article P, paragraph 1 of the fundamental law. This states that natural resources shall form the common heritage of the nation, and it shall be the obligation of the state and of everyone to protect and maintain them, as well as to preserve them for future generations. What is interesting is that the fundamental law gives an exemplificative list of natural resources, for example, arable land, forests, or water resources, as well as biodiversity. And another important concept of the fundamental law is the common heritage of the nation, and thereby referring to heritage, the legislator aims to imply that this is not only it does not only have a commercial character, but there is another intrinsic value which we should bequeath to the next generations. There is a triple obligation, which is the protection and the maintenance and the preservation, which was interpreted by the Constitutional Court, and we can state that the CC mainly declared or reaffirmed the international scientific viewpoint of Edith Brown, which we have heard before in the morning. As I have mentioned, future generations, the protection of the interests or the needs of future generations appear at several points of the fundamental law, of which the framework is again provided by the national law, stating that it is an alliance among Hungarians of the past, the present and the future. And in my opinion, it is very interesting because it states not only the intergenerational link between the generations, but also that Hungarians of the future, and it is particularly important if we take into account the decreasing Hungarian population. Another interesting fact is that future generations are linked not only to the protection of natural resources, but also to public funds, stating that the management and the protection of natural assets shall aim at preserving natural resources as well as taking into account the needs of future generations. Sustainable development is also pronounced by the fundamental law in the framework of international cooperation. The Hungarian fundamental law expresses several value choices, and one of them is a very important one, which is the protection of the Christian culture. And it appears several times in the Hungarian fundamental law, in the national law, for example. And why it is relevant for environmental protection or for the protection of the interests of future generations. It's because environmental protection or taking care of the needs of future generations is not a mere state task, but it has moral, ethical foundations, which were pronounced by several Christian religious leaders. And what is very interesting is that the last two ones, the work of Pope Francis and of Patriarch Bartholomeus, was referred to by Constitutional Court decision. Another important and relevant provision of the Hungarian fundamental law is pronounced in Article L, which states that the Hungarian state encourages childbearing, and in my opinion it is important for future generations because, and it differs from child protection, because encouragement to have children rather implies the protection of unborn generation who are not born yet, and they might be linked to future generations. As for financial sustainability, of course, the framework is provided by the preamble and Article N, which says that Hungary shall observe the principle of sustainable budget management. And what is an interesting and important rule in relation to financial sustainability is the rule on government debt, which states that the government debt may not exceed half of the GDP, and it could be linked to the interest of future generations according to the explanatory memorandum of this article, because it clearly wishes to avoid the indebtedness for future generations and thereby taking care of their needs and interests. As for the protection of national assets, first we can differentiate between the property of the state and the property of local governments. And again, the needs of future generations appear in relation with national assets as well. However, we should note that national assets may not equal to the common heritage of the nation, but they might overlap, like it was in the case, the Constitutional Court decision of 2018 in relation with groundwater resources. So in that case, national assets and the common heritage of the nation, natural resources, are the same category, but not in all cases. So in order to shortly summarize, I would like to point out the interesting and the valuable points of the Hungarian fundamental law in relation with the protection of the environment and future generations. So first of all, the right to a healthy environment is explicitly guaranteed by the fundamental law, and its history dates back to the beginning of the 90s, because it was also pronounced by the former Hungarian constitution. We should also mention and bear in mind the prominent role of the Constitutional Court in its interpretation of the environmental principles, and I would like to refer back to what I said in the beginning, that the principle of non-derogation and the precautionary principles were elaborated by the Constitutional Court. Another positive aspect of the Hungarian fundamental law in relation with environmental protection is that we have a Deputy Commissioner for Fundamental Rights Ombudsman who is responsible for future generations, and his work is acknowledged on an international level. And the needs of, or the interests of future generations are also taken into account. At several points they appear in relation with not only with the environmental protection or the protection of natural resources, but also in relation with public finances regarding the principle of sustainable budget management or the rule on public debt. And last but not least, I would like to point out certain problematic issues and questions. So first of all, the question of liability for environmental damage. It is still not clear to what extent it represents the polluter pays principle. I would like to note that the former Ombudsman for Future Generations, in his legislative proposal for the fundamental law, suggested the explicit mention of the polluter pays principle, the non-derogation principle, and the precautionary principle, among others. But as we know, it did not, it wasn't realized. And the fact that the fundamental law states that anyone who causes damage for the environment, the question arises whether it shall establish the liability of non-state actors, especially of multinational companies. So this is still an ongoing question. And finally, I was inspired by the previous presentations where I heard that several constitutions declare rights enshrined in the Aarhus Convention, procedural rights, for example, the right to access to adequate information on the state of the environment or participation in the decision-making process, which, in my opinion, might be a consideration for the future. And thank you very much for your attention.